Hello again, everyone. It's Rob Ryder on Sunday, December 7th, 2014. And today, I find fault with your form. This is a class action of biblical proportions. Well, it's at least epic proportions, but close enough to biblical for me. We're going to look at a small sampling of 3 different states' tickets. And questions we have are, do these tickets, conform? In other words, are they as they were supposed to be? Or are they administered according to their originator's mandate? And just real quick, most of these forms are, there's a committee under the Supreme Court, put together by the Supreme Court. Illinois is the chief judges of all the circuits who decide on a number of things, and some of those are what the forms are going to be that go into their courts. And make a long story short, they're not always using the form in the manner that it was designed by the people that designed it. And so since they've changed the form without getting any authorization, well, they're in indirect contempt of court of the Supreme Court. And we should point that out. Now in Michigan, it looks like they do use the right form, but they blatantly don't fill it out correctly. And so again, that would be another indication of indirect contempt of court. And all of these forms, now we're talking about for traffic, civil violations, things like that, go through the prosecutor's office. And so ultimately, the prosecutor is the one responsible for what goes into the court, and it's the prosecutor's office that is committing this indirect contempt of the Supreme Court. And so you would possibly put a complaint into the Attorney Disciplinary Board for the prosecutor for using a form that doesn't conform to what the law says they should be using. So we're going to look at some of these so you can get an idea what they look like. But not only might they be wrong, they might be submitted into 2 different jurisdictions. In other words, 2 offenses for the same act. Right? Not being charged twice for the same offense. No, 2 separate offenses for the same act. One going into one jurisdiction, one going into another. Arizona traffic ticket and complaint you receive may contain both state law violations and city ordinance violations. Sedona, Arizona. Came off their website. Well, you can't go to a state court for city ordinances, and you can't go to a city ordinance court for state law violations. They're 2 different jurisdictions. And yet, there they are. So you go to the state court because that's where it looks like you maybe you're supposed to go, and you don't take care of the city ordinance side, and the city ordinance side says if you don't take care of this, because it's a city ordinance, well, you're in contempt of court because you didn't appear. They make it so you have to appear for city ordinances. But you don't necessarily appear at the state court. You appear in the city court, or the city traffic bureau, or whatever other name they might have for it. So when you find these errors and omissions, well, what then? And that's kind of what we're going to talk about, is what we might do with this. Again, I don't really know exactly what to do. I'm just guessing based on research. And this week we'll try a few things, and we've got a few things we're trying now, and the weekend gets in the way, and you got to wait and see what next week brings. So, and so then, by the way, Rob Ryder needs your money. PayPal account is ashleyritluski@gmail.com. And my mail address is Robert Ritluski. Of course, that's my correct name. 10955 14 Mile Road, Rockford, Michigan, 49341. This is the 7th of December. I haven't paid my rent yet. And I could really use some help. I hate to have to go out and get a job. I'd rather be doing this. Right? If it was just about the money, well, I can make money all sorts of ways. I go sell crack cocaine to your kids. But I choose not to. So, I don't need much, but I need a little bit more than I'm getting, and if you can help, it's a wonderful, 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 wonderful day. So, let's look first at what's going on in Arizona. let's do that. What do we do first? Excuse me. But first of all, I want you to stop and write down the PayPal account address. Send a little kicker. Put something in the mail. Wonderful day. Appreciate it. What we did last week is we put a complaint in for Bob. Bob. And we put a complaint in about this ticket right here. This is the ticket that he got. And so you know, this ticket here doesn't in any shape or fashion comply with what they show should be being used, and it doesn't appear, since we've checked, that these people have any authorization to have made the changes. But before we knew that, we were just complaining about the ticket. So let's go on to that. Okay, guideline bag complaint to Bob. This was back like in the end of sometime in November. So what we were saying is the City of Surprise, Arizona, individuals representing the respondent participated in numerous violations of the Arizona revised statutes, including criminal impersonation, fraudulent schemes and practices, willful concealment, perjury, classification. Further, the complaint and civil rights were violated by use of color law and simulated legal process in violation of numerous federal civil rights acts, the same being the supreme law of the land. The Constitution allowed the Congress to make needful rules, and they did, and they called them acts of Congress, and they said these are the supreme laws of the land, and you can go back to the very first Civil Rights Act of 1866, and when you read them, they all talk about using color law is a civil rights violation. So, and then we just pointed out some of the things that were wrong with the complaint. No mailing address. No mailing address? What the heck's that about? Well, sure. Right here. No mailing address. All right, they got a resident commercial address, but they don't have a mailing address. Well, how can they mail you anything? Defendant never signed the complaint. No signature was asked for, as the unidentified representative of the respondent simply wrote "in custody" in place of the signature. Well, by writing "in custody," he said you're under arrest. But this is where Bob should have signed where this X is, and you can't see it, but it says "in custody." And this is when he's supposed to show up in court, and up here it says "in custody." So, like, well, then how, at the date and time indicated, in custody. Like he's not supposed to show up. It didn't say when to show up. The unidentified representative of the respondent initiated, the unidentified representative, that would be the guy pretending to be the peace officer. The respondent is the Surprise City Police Department. Initiated a false certification in violation of Arizona Revised Statute 133899B, which says a false certification under the provisions of subsection A of this section shall constitute perjury. The form used by the representative is not in compliance with the state law to allow filing of as a complaint without first swearing said complaint before the proper magistrate, regardless if the complainant was a peace officer or not. So they had this form set up with certain words on it, and if they did it that way and a peace officer signed it, he didn't have to go before a magistrate first to swear out the complaint. But they changed the words, and we're not sure the guy's a peace officer. Therefore, for this complaint to have any validity, it would have needed to have been sworn to before a magistrate. Only a peace officer can arrest someone, and there's no evidence that an unidentified representative of the respondent is a duly sworn public officer with badge and underarms. Right? Peace officer has a particular definition, takes particular things to be, and otherwise they're just they need to be an officer of the state or an officer of the municipality. They can't just be an employee. As far as a peace officer. The documentary evidence seems to indicate an attempt to defraud the defendant by referring to the court that is not part of the state judicial system. Surprise City Court is not within the criminal justice system of Arizona. According to the Arizona Criminal Justice Commission, the city court for Surprise Municipal. The city court is the Surprise Municipal Court in Suite 105, yada yada yada. So they got a doorway that says Surprise City Court, but the city court is actually the Surprise Municipal Court, which is some room inside of the city hall, not the big door where you see Surprise City Court. In violation of the supreme law of the land in the form of various civil rights acts, Congress, color of law, has been prosecuted against complainant under case whatever in a for-profit business called Surprise City Court, located at 160. Yep. So basically we're saying because he didn't take us to the right court, or he didn't take Bob to the right court, that this is just color of law in the simulated legal process, and that is a civil rights violation by the Congress. So basically that was it. Now, we sent this complaint to the city manager of Surprise, because the city manager ultimately is the top law enforcement man within the jurisdiction. He is charged with enforcing all laws and ordinances within the city. And it didn't say city laws, because those are ordinances. So what laws are they talking about? Well, how about these state laws that we're pointing out? Okay, so that's what we sent, and not surprisingly, it got an answer that basically ignored everything that we said and just said, well, according to, I've done my investigation, and apparently you pleaded guilty on such and such a date, and yada yada yada, and you're on probation, and have a great day. So we went back to him on Friday, and his name happens to be Bob, right? I'm a Bob. The guy I'm talking about in Arizona is Bob, and the guy at the city is Bob. So Bob, I do appreciate the response to my complaint. I went ahead and did some more digging to make it as simple as possible to showing you where the law isn't being filed in your city. All I want you to focus on, Bob, is the words under where the complainant signs the uniform traffic ticket and citation for the whole state, approved by legislature and Supreme Court. I'll show you what the ARS statute says, what the Supreme Court says, and what your city complaint says. So, first of all, what the statute says: certification of a uniform traffic complaint form. False certification. A uniform traffic complaint form need not be sworn to if they contain a form of the certification by the issuing officer in substance as follows. So this is what the law says. I hereby certify that I have reasonable grounds to believe, and do believe, that the person named herein committed the offense or civil violation described herein contrary to law. And then it goes on to say, a false certification under the provision of subsection A is perjury. So if it doesn't meet the criteria of A, then it's a false certification, and it's B, perjury. So on the ticket, it says, I don't know if you can read that or not. Pop it up one more time. I certify upon reasonable grounds, I believe the person named above committed the acts described, and I have served a copy of this complaint upon the defendant. That's what the one that they gave Bob says. What the law says is, I hereby certify that I have reasonable grounds to believe and do believe that the person named herein committed the offense or civil violation described herein contrary to law. That's what the law says, and this doesn't say that. So, I certify upon reasonable grounds I believe the person named above committed the acts. I hereby certify that I have reasonable grounds to believe and do believe the person named herein committed the offense or civil violation described herein contrary to law. That's a big thing, contrary to law. There's nothing in here about being contrary to law. So, this form that the City of Surprise is using, beyond the other changes that they've made, that's the biggie to me, right? It doesn't conform to what the originators of the form said it should. Now, where do you find that kind of stuff? Well, on the on the guidelines. So on the Arizona Courts website, under Court Services, guidelines for submittal of Arizona Traffic Ticket and Complaint Forms. The Arizona Traffic Ticket and Complaint Form, the ATTC form, is a multi-agency form that affects the public, the courts, and law enforcement. Therefore, law enforcement agencies are strongly encouraged to work with their applicable courts prior to submitting changes to the ATTC form. Rule 4, Arizona Rules of Procedure in Civil Traffic Violation Cases, and Rule 3, Arizona Rules of Procedure in Traffic Cases and Boating Cases, requires each law enforcement agency or public body responsible for issuing ATTC form to submit any substantial variation to the ATTC form to the Supreme Court for approval. And you can't read this, but it does say Arizona Traffic Ticket and Complaint, ATTC form. And the Supreme Court would like to know if you're going to change their form. The substantial variation examples illustrate what is considered a substantial variation in the ATTC form. This is not an all-inclusive and may not address each agency's particular situation. So, approval of an e-citation, handheld ATTC form. The format. Its own smart print program is available at AZ Tech. Of course, for free. A citation, which was developed with cooperation of the ALC, the courts, and the vendor, is available template format. So one of the approved changes they did was, it looks like this. Right? And they call it a citation. Right? So this is to change it to a citation. Now, right, approval of an e-citation, handheld ATTC form. Right, so now it's not called an ATTC form, it's called a citation. And this was approved by the courts. And they did change the wording. I mean, even the courts changed the wording on this down here compared to what the law says. Now, statutorily, can they do that? And this would be another question, right? So this now becomes a question of the law. And it's a question that you could take directly to the Supreme Court because they have jurisdiction, original jurisdiction over things that have to do with the constitutions. So if who was given the question is, who was given the authority to write the law and use certain words? And that would have been the legislature, and they used certain words, and the courts changed it. But it still says contrary to law, right? I certify upon reasonable grounds, I believe the defendant committed the above acts. So even this isn't the same as what the City of Surprise used. This is different still. We still don't know if they got their approval. Approval is needed. You must submit citation for approval. However, the process should be fairly quickly simplified using the template format. Right? So even if you use the template format, citation for approval by the Supreme Court, everything needs to be approved by the Supreme Court. And you would send it to this Marietta Mathis, Arizona Supreme Court, Court Services Division, gives the address. Well, then they got a photo enforcement one. Approval is needed. All photo enforcement citations must be submitted to the Supreme Court for approval, as a photo enforcement citation is substantially different from the Arizona Traffic Ticket and Complaint Form, provided for in the Arizona Rules of Court, Rules of Procedure, in traffic cases and voting cases, Appendix A, and is considered a substantial variation. So those you got to send to Marietta. Approval of parking, animal control, or officer-issued ATTC. Approval is needed. Agencies must complete the request for approval. To approve a substantial variation, so they have a request form to fill out. For the form, for consideration of any proposed substantial variation to the Arizona Traffic Ticket Complaint Form. A citation is considered substantially different and will require approval by the Supreme Court if it deviates from the ATTC form, provided for in the rules. Jeepers, you're going to change it, you got to put in a change order. It goes down to tell you what substantial variations are. Removal or addition of any data contained on the form. Change in the size, the format, and content of the form. A deviation from Rule 3 or 4. Any verbiage or language change on the front or reverse of the form. Well, apparently these words have been changed, and it's substantially different than. I guess we should look at what it should look like, what we believe it looks like today. But we're going to wait and let the Supreme Court tell us. All right, here's the change form. That seal is the Supreme Court seal, and so if they want to put a change in, the date, the contact person, the agency name, the agency's address, the contact's email, the contact's office phone, please provide a detailed explanation of each proposed change, the ATTC form, and why each change is necessary. Please attach your proposed ATTC form and current ATCC form here. What are you using now, and what is it you want to do to change it? Right? So if they wanted to do any changes considered substantial, which is just as simple as changing the wording, they had to put this in. And we haven't found that yet. This lady hasn't found it yet. So we sent all this stuff to Marietta, asking her about it. And so we sent her a copy. What did Bob do? First, Bob asked if there were any changes to if she had on record any changes submitted by the Surprise City Court. And then we decided to send in, or Surprise City Police Department, a copy of what he had and said, this is what they're using now. Is this what you have on file? And as it turned out, it wasn't. And we said, well, send us what you have on file. And whatever change it was from 2006. But what she didn't send was any notice. Right? She didn't send this. Well, where is this that they asked to do this? Do you just have it in your file? Does somebody stick it in your file, or did they go through the process of asking for these things to be changed? And she wanted to wait until Monday to talk to the agency, which must be the City of Surprise, to find out what they have to say. So that's kind of where it sits. Now, right, this is the classic. This is the way apparently it was meant to look like when they first came up with it. And if you were to take this and compare it to what they gave Bob, you'd see all sorts of differences. Like, see where it says violations in the big lettering. Well, it's supposed to say docket number, disposition codes, date of disposition, sanction. There instead. Insert here the place of appearance, title, name, court, judge, or juvenile referee, yada, yada, yada. Right? You must appear. Surprise City Court. Now, this is interesting. Court number 0761. Right? Well, that isn't on the sign outside. What is this court number 0761? It turns out that the valid courts seem to have some kind of number attached to them. So anyways, substantial changes. We're waiting to find out what they have to say. Now, based on all that, we decided to go back to the city manager now, since we got a pretty good idea that, hey, you guys don't have the right form, and point it out to him because, he's not necessarily in on the loop in this stuff, so we're going to, educate him. So, Bob, right, the false certification. Supreme Court approved form says I certify, yada, yada, right? Their form says I certify. These are all different. Bob, as you can see, your city police complaint citation form wording is different than the others. You modified an approved form created by the Arizona Supreme Court, right? You did, Bob, because you are responsible as the chief administrator of the city for everything that happens in your jurisdiction. You're the captain. You can go down with the ship. By modifying the certificate on the form without approval or guidance would make it necessary for the officer to swear his complaint before the proper magistrate, or he has committed a false certification. Again, that's just straight out of their law. So where's the sworn complaint? The law says it doesn't need to be sworn to is substantially the same. Well, yours does not match the state statute or the Arizona Supreme Court approved one. Bob, there needs to be a sworn complaint or it's perjury. Now, what you're thinking, or the attorney will tell you, is that we can change it as long as we go to the Arizona Supreme Court Court Services Division. That's true, but you need to have filled out an ATTC change form I've attached. The Supreme Court would need to give the approval of the changes because it's substantial variation of the Supreme Court form. Definition of substantial variation is, and we've already looked at them, any verbiage or language change front or back of the form. Did your agency get the approval of the Supreme Court? If so, where is the letter? Right? Where is the what were we calling it? What were we doing the IRS stuff? The determination letter. Where's the determination by the Supreme Court? Where are any request forms sent to the Supreme Court Court Services Division asking to change the complaint verbiage? Bob, the reason I am pointing this out is if the form doesn't match what the law says and the agency never got the approval, then it's indirect criminal contempt of court by your legal counsel and now you personally, as I have made you aware of the crime. There never was a lawful court case against me, and I ask you to return all my property plus damages. In closing, be aware that the attorneys representing the city are engaging in official misconduct and false personation of a public officer if they use any name other than the one registered with the clerk of the Supreme Court on the roll of attorneys. If that name is the full name, then they had better be signing papers in that name. The use of the middle initial instead of a full name on any other deviation from the name certified with the clerk is official misconduct, false personation of a public officer. Book 'em, Dano. So basically, I'm trying to get Bob out of this, or we're trying to get Bob out of this. Bob being Bob, the city manager, blame it on the attorneys. They're the ones that did it. It all goes through them. They're the ones learned in the law, and they're allowing these change forms to be used in court. Right? And so what does that mean? Well, it means any ticket written by the Arizona Traffic Ticket and Complaint Surprise Police Department form, that on any form they've ever had that deviates from what the Supreme Court said to use, that they don't have any changes for, they're all color law simulated legal process. It's indirect contempt of court. It's class action lawsuit. That should get an attorney interested. Take it to an attorney. And so that's what Bob is doing. We found an attorney who uses his name properly on the Bar Association. We're going to take it to him. Say, hey, this is a class action lawsuit, right? This is bigger than a cigarette bust. All of them are wrong in every city. So the attorneys that get in early, they can make a shitload of money, and the rest of them will be left high and dry because they won't be able to use these forms anymore. That'd be a glorious day. All right, so that's kind of how it worked out in. This is right out of line. It's hard to deny what it says. Require each law enforcement agency or public body responsible for issuing ATTCs to submit any substantial variation to the ATTC form to the Supreme Court for approval. And if you haven't done that and you've changed their form, well, that is indirect contempt of court of the Supreme Court. They had a rule, said what you had to do. Excuse me. And then it goes on to say, procedure for prosecuting civil and criminal violations in the city court. The city may use, again, this is City of Surprise, the city may use the procedure established in this chapter to enforce every city ordinance and to prosecute any civil or criminal violation of every such ordinance. So they have to charge you with an ordinance. They can't charge you with a state statute violation. And on here, these sections are using, these are Arizona revised statute, right? They can't charge you for an Arizona revised statute in the city. They can only charge you for a city ordinance. But that isn't what they did. All right. Okay, I'm going to pause for just a second here, go get some other papers. Okay, this is Illinois Supreme Court rules. Rule 552, uniform tickets processing. Uniform citation and complaint forms and conservation complaints shall be in forms which may from time to time be approved by the Conference of Chief Circuit Judges and filed with this court. What court? The Supreme Court. The uniform forms shall be adapted for use by municipalities. The arresting officer shall complete the forms or ticket, and within 48 hours after the arrest shall transmit the portions entitled complaint and disposition report, and, where appropriate, report of conviction, either in person or in mail, to the clerk of the circuit court of the county in which the violation occurred. Each uniform citation complaint form and conservation complaint form shall, upon receipt by clerk, be assigned a separate case number, chronologically, including multiple citations issued to the same accused for more than one offense arising out of the same occurrence. They're going to get different numbers. A final disposition noted on the reverse of the complaint shall be evidence of the judgment of the case. Right? So there's one of these that says complaint on it, and there's other ones that say other words, but the final disposition notice on the reverse side of the complaint. Excuse me. Upon final disposition of each case, the clerk shall execute a disposition report and promptly forward it to the law enforcement agency issuing the ticket. Yada, yada, yada. So what does all that mean? Well, what it means is that there's this group called the Conference of the Chief Circuit Judges. There's 20-some, 25, 30-some circuits in Illinois, and each one's got a chief circuit judge, and they get together, and they not only this form, but other forms, right? They agree on what the forms are going to be used within a particular court. And they agreed that the uniform citation and complaint form would look like this. All right, here's the complaint copy. I don't know if you can see that, and I'll make it a little bit bigger. All right, now, before we go any further, let's just compare that, because this is supposed to be adapted by the various municipalities. Well, this is the one they used on Roe. All right, I would say there's some, without even reading it, there have been some substantial changes. See, it says complaint. It says complaint. Right? So they didn't use the form that the Supreme Court says they're supposed to use in the jurisdiction. And we're not going to sit here and read this whole thing because I don't know that we need to, but use a separate citation for each violation. So where in Arizona you could see they had multiple violations on the same form, here every violation gets its own citation, citation, separate citation for each violation. Now, in Roe's case, it was just disorderly conduct, alleged offense, disorderly conduct. However, when you read the definition of offense in Illinois, that would be the statute number. That's the offense, and then there's verbiage that goes with it. But the offense is the statute. You got to write the statute number down, and they didn't. Right? They wrote disorderly conduct. This chapter and section, this doesn't have necessarily anything to do with anything. That could be out of the ordinance violation. All right, so this has been, on some of these are blank on the back. I don't know if there's anything. And on some of them there aren't. Report a conviction. So this is like a 6-page form. So when you get a ticket, you're only getting one page, right? You're getting the page that goes to the defendant. But there's many other forms. Police record for the violator. What's it say in the back of the violators? Read these instructions carefully. If your ticket is marked X, court appearance required. All right, well, it's definitely marked X, right? Down here, they just cross out everything to do with appearing in court. Does that mean it's marked X? I don't know. Oh, if it's marked no court, then don't show up, right? Well, they didn't mark either of those boxes. They just crossed out the whole damn thing on Roe's. See, here's the boxes. They're not, neither of those boxes are checked. They crossed out the whole thing in the bottom. Bond information, failure to appear, yada, 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 right? You can go read this stuff some other time, someplace else, easy enough to find. The Conference of Chief Circuit Judges, Administrative Office of the Illinois Courts. So the chief administrator of the courts is the secretary for this group. Now, I want to point something out before I forget all about this. What we're seeing is when people have been told you've not exhausted your administrative remedies. It can mean it means lots of different things. But one of the things it could mean is when you look at the way the Supreme Court's been set up, the chief judge is picked, and he's going to be the chief administrator of the court. And then the Supreme Court appoints him an administrator. So the director of the Administrative Office of Illinois Courts is the administrator who's been picked by the Supreme Court to help the chief judge administer the courts. Well, administration is the executive side, right? There's your administrative remedy over there. Because like a mandamus, really, it's an administrative order telling the courts below, or it's the unit below, whoever it is, to do or to not do something. We're not going to get the law judged, right? That would be an appeal. And that would be the rest of the court going to the court clerk. I think you need to bring this stuff to the administrative office of the Illinois courts, to them, to this clerk. Now we're going to call this director the clerk of the chief judge on the administrative side, to point out what's happened so that the chief judge can hand down an order in the form of a mandamus to whoever it is below, telling them to do or not do something. And we should never have been in court, right? This is all administrative. And, right, so the Conference of Chief Circuit Judges, mandated by the Supreme Court, has come up with what they want the Uniform Citation and Complaint Form to look like, and that isn't what they're using here in Kane County, right? Kane County Sheriff. It's like, come on, you can't even spell sheriff right. It was done on purpose. Right? This whole thing is a simulated legal process. So, right? Now they had another one for the DNR, right? Illinois, because it talked about the uniform traffic ticket and the Illinois conservation complaint. Right? And that one looks something like this. And it says, must be red, must be bold-faced, must be. And the main thing is, I didn't get to that. Let's go to the last page here. We get down to the printing instructions. For wherever they're going to send this to be printed. Printing instructions. Right, a written request. A written request by law enforcement agency to the clerk of the circuit court so upon a written request by a law enforcement agency to the clerk of the circuit court, the chief judge of that circuit may, with concurrence of the clerk of the circuit court, request the conference of chief circuit judges to authorize the admission of report of conviction and court. Right? So if they want to remove, they could remove a couple of these different forms that don't need to be in there. It takes written request. Right? All printing on the face uniform ticket will be black lettering except for the following. Titles of each box to be red bar with white lettering. The following will be in red print. And it tells you what they need to put in red print. This tells you what the damn form needs to look like. And when you get down here to the bottom, no additional modifications to the printing of the uniform ticket are authorized. And the one that they used against Roe looks nothing like the one that they're supposed to be using. And so we're going to do, maybe, something with them, which would be like, right to the chief judge. Here's another interesting thing. So whenever this group gets together, these chief judges, right, this conference of the chief circuit judges, whenever they get together and they make up forms, the way the forms look, like here's another approved form. I guess that's what I'm trying to get to. This is the way they do the heading of the form. Circuit Court of Illinois, as in there's one Circuit Court of Illinois. 19th Judicial Circuit, Lake County. This is an approved form. Form approved by Conference of Chief Circuit Judges. Well, so the question is, well, what other forms have they approved? Let's start there and get a whole list of all the forms that have been approved by whoever approves the damn forms. And see what they say. And so if you want to contact them, it seems like this is the way, if you're going to put court paperwork in that you want this organization to pay attention to, into the right jurisdiction. The right jurisdiction is the Circuit Court of Illinois, 19th Judicial Circuit, Lake County. Not in the Circuit Court for the 19th Judicial Circuit, Lake County, Illinois, zip code, right? Which is how you see a lot of the paperwork that isn't on an approved form, but things that are made up by the attorneys, right? They're intentionally not putting it into the right court. And so this is on an approved form. This is what the chief judges are saying the court is. It's the Circuit Court of Illinois, and then whatever judicial circuit you're in, and then whatever county you're in. It would seem. So all that being said, what we're going to do is send this to Judy Mary Brokaw, who is the chief judge, but because she signed her oath as Judith M. Brokaw, well, Judith M. was never an attorney, so that could never have been a judge. So I don't know how to start this thing, but I thought we'd start it this way. Forgive me, I am not sure of your lawful title. It appears on ARDC, the Attorney Registration and Disciplinary Commission, which is under the Supreme Court, that Judith Mary Brokaw is a full licensed name of an individual attorney authorized to practice law within Illinois, who is now also holding the office of Chief Judge of a Judicial Circuit under the assumed name Judith M. Brokaw. Is it lawful to hold two public offices under different names? How is it that Judith M. Brokaw, who was never and could not have, who is never an attorney, as you can see, this is a work in progress, who was never an attorney and could not have been elected or appointed judge? Have you vacated your office and merely usurped its powers? They might want to change. I don't know how strong we want to be going in, because we're trying to get them to do something for us. Nevertheless, you and those like you participate in your Conference of Chief Circuit Judges. Among other things, this conference approves the forms used in the Circuit Court of Illinois. Further, it appears you have been appointed to govern the courts and practice of law by rules of your private society within a defined territory, namely the 16th Judicial Circuit of the Circuit Court of Illinois. So that's where Judith is. Now, the attorneys and the judges, because they are attorneys, and the Supreme Court regulates the practice of law within the state. The Supreme Court says you got to be a member of the state bar to practice in the state courts. And to be a member of the state bar, you need to certify your name and certify your business address and certify this account that they have that is used for third party and client property. Well, if their client's property is one kind of property, who's the third party? Well, that would be you, your property they're trying to take from you. But they have to certify all these things. And so it's a membership-only club, right? It's a private club, basically. Private membership, private society, has its own professional rules of conduct and professional judicial canons, and all these rules that apply to those that are within the membership. So whether they're a judge for me or not is yet to be determined, but certainly within their own membership of those who volunteered to be in it, here's the rules they agreed to. And we're going to point out some of those. So I'm sorry to have to inform you that your subordinate officers of court, fellow members of your private society, bound by your rules, are habitually using unapproved forms in your court, rendering the proceedings not only illegitimate and an indirect criminal contempt of court, but also nothing less than an international crime against humanity. According to Illinois Supreme Court Rule 552 in pertinent part, uniform citation, complaint form, conversation, complaint shall be in forms which may from time to time be approved by the conference of chief judges and filed with this court. The uniform form shall be adapted for use by municipalities. I'm providing you documentary evidence of the one that she was served, of an unapproved uniform citation and complaint form that was filed in your court under Gen number, it's Exhibit A. The use of this unapproved uniform citation and complaint form is indirect criminal contempt of the Illinois Supreme Court, and the officers involved have brought fraud upon said court by participating in official misconduct and false personation of a public officer. It is the will of the Lord that you make them stop now. I want to get a little biblical on them. I don't know if Rogue's going to agree with that stuff or not, but yeah, that's what I do. Right? I just write them, go back and tailor them. We haven't sent this yet. This is just ideas. The use of color law and simulated legal process is a civil rights violation, and the enforced disappearance of my person is considered enslavement. Right? You got a proper persona. It's your proper name, Robert Allen Rytlewski. In my case, not all caps, just the proper name. But that isn't what they sue you in. When you go look at the docket, it will be Rytlewski, Robert Allen. They are the enforced disappearance of my proper persona, so that I cannot claim my sui juris legal personality and sue and be sued in my proper name. Right? I got a defect, or I got a, they're saying that we need to have a guardian, administrator, so forth and so on. So the one they gave Roe is a simulated legal process using color law, as is the unapproved bail bond form, which they used against her, and the unapproved arrest warrant, which they used against her. Now, I don't even know if these people approve those or not, but the ones they have are certainly not lawful compared to the other ones that you can find online. Right? There's significant differences. They are used as part of a scheme perpetrated by organized criminal societies usurping the sovereign powers of state to hide their participation in antitrust activity. Basically, that's all they're doing. It's just a way to make money. Article 8, Illinois Rules of Professional Conduct of 2012, Rule 5.5, Unauthorized Practice of Law, Multi-Jurisdictional Practice of Law, and Rule 8.3, Reporting Professional Misconduct, taken together, make it dereliction of duty of one Judith Mary Browkaw, authorized attorney and counselor at law, not to prosecute these violations. Because she's a member under that name, she's agreed to these rules, and when you go read what they say, when she's made aware of it, she needs to go point it out. She needs to put the complaint in. That's the same with any attorney. As captain of the ship, you, Judith Mary Browkaw, are responsible for their behavior, and it is the will of the Lord that you make them stop now. All right, the Lord wants us to live at peace. It's His will that you make them stop, because they are bringing the controversy. They are the ones who are charging their brother. They're the ones not treating their brother like they'd like to be treated. Judith Mary Browkaw, why do you persecute me? I have provided you evidence of my citizenship in the kingdom of heaven in the form of my baptismal certificate. I do not consent to a presumed jurisdiction over my property or myself. I demand you enforce your private society's laws over those who have freely consented to your jurisdiction. If you somehow feel you have lawful authority over me, then you must immediately inform Vatican City State of my request that they represent me in this matter. I appeal to the Sovereign Pontiff Francis I. See that he is informed. For the record, I'm an immortal spirit, child of God. Here is one of his people who has chosen a state of life as a citizen of the Holy See, and freely give the Catholic Church in personam jurisdiction over my persons. They got their own courts. You got a problem with me, take me to the church court. They will make you swear to it. Right? So if you have a baptismal certificate, whether you like it or not, realize it or not, it appears, right, that should be your evidence that you are a citizen of the Holy See, and the Holy See has its own country called the Vatican City State, and even though you don't live there, you live out in a missionary church called the United States of America. I don't know if that's what the church is called now, but the Church of America, right? That your citizenship is over in the Holy See, and you're a lay apostle out here preaching the gospel. Right? So if you got a... Rod Class was saying that his brother found out while Rod was in jail, and he got a hold of the UN, talking about the courts didn't have any jurisdiction over Rod. And that technically he was, what they call him? A resident alien. So you're not seen as a citizen of the United States. Now this is all based on, this part comes from the fact that on the Social Security, they have a master file, just like the IRS got a master file. I think it's 65 or something like that. And it talks about it having a section in there about your citizenship and all this other information about you. And then this information is shared with all the other organizations, city, state, federal, about who you are, right? It's where they get your identity from. And on that form, apparently, it says, if what Rod is saying, that we're, according to the UN, or whoever they talk to the UN, that compared to the courts, we're seen as resident aliens, well then, whose citizenship do we have? It should be listed on the master file kept by the Social Security Administration. And I talked about it in a video here a little bit ago. In fact, I sent the paperwork in to get mine, and I'm still waiting to get it or hear from them. And yeah, we'll give it another week or so and see what happens. But anyways, that's another story altogether. My point is, they're not using the right forms, right? So point it out. Okay, going to do one more. Going to look at Michigan here. So let me stop this. Okay, we're back. And by the way, Rob Ryder still needs your money. If you can help me out, I really appreciate it. Now, in Michigan, what do we have? What did it say about Michigan? Well, it says that the Uniform Law Citation, Commercial Law Citation, and Citation Book cover, revised in 605. Right, the State Court Administrator Office has extended the use of older versions under certain circumstances. This extension does not apply to printers. The 0605 must be used when stock is reordered. Right, so they put in something in there. And then the agency wishing to contract with their own vendor may obtain an electronic version of the revised forms by contacting the Michigan Supreme Court State Court Administrator's Office. Apparently they want to know what you're doing with their forms. And there was one other interesting. I didn't pull that one up, but what did it say? What did it say? What did it say? Mandatory creation of or use of SCAO, State Court Administrator Office approved forms. The following list identify court forms that are required by court rule or statute to be approved by the SCAO, used as approved by the SCAO, or used in a form substantially in the form approved by the SCAO. So forms SCAO has mandated to create and approve, used, not mandatory. So these would be the ones that, you don't need to use these here, these MC, whatever. However, they got to be substantially the same. But that ain't the one we want to look at, because they do have mandatory use. And right here is the ones we're talking about. A UC01A and a UC01B are mandatory forms, must be used. Good enough for me. Let's go see what they look like. Okay, what was this? No, not that one. Alright, so here's one of them. Now, I don't have any of these. Anybody in Michigan who's gotten a ticket recently, if you can send me a copy of your ticket, don't mind me using it in a video, number one. Send me a copy of your ticket, front and back, because these are all multi copy forms with fronts and backs on them. So, in Michigan, as I remember, I've seen this, and it's like somebody who sent me one before. I can't find it. It looked like it was pretty much done this way. Right? That was what I wanted to get. Let me show you something. So here's one. Here's an example from Sterling Heights. And right off the bat, they're going to charge you in two different jurisdictions. The people of the state of Michigan are going to charge you, and the city of Sterling Heights is going to charge you. Now, the rest of this form looks like it's the proper form, but they check two boxes right off the bat. You're going to get charged two different jurisdictions. Within the city of Sterling Heights in the county of Macomb, they're supposed to write down what these are here. Within 10 days. Now, right, look at this line here. Might be easier to see on this one. It says, in the blank, court of blank. Court address, phone number. In the blank, court of blank. In the 41st A district. Now, we have district courts in Michigan, and there's a whole bunch of them. Like I'm in 62B or something like that, 62A, 61A, 62B, who knows, something like that. But district is really like an election district for state elections or something like that. State representatives. Where they're really taking this to is the court of Sterling Heights. And then it says, I served a copy of the civil infraction complaint upon the defendant. I served a copy of the civil infraction complaint. Well, they didn't say it was a misdemeanor or traffic infraction. It's a civil infraction, and a civil infraction has its own freaking definition. Right? Civil infractions are municipal civil infraction. A municipal civil infraction action is commenced upon issuance of a citation. The city of Troy is the plaintiff in a case involving a violation of city of Troy ordinance. Now, I know what we're looking at isn't city of Troy, but nevertheless, right, that means that you're being charged in this case by the city of Sterling Heights. And the city of Sterling Heights has got an administrative hearing officer someplace that you're supposed to go to, like a traffic bureau or something that's probably in City Hall. But they're going to get you to go to this other court. Now this is going to be the 41A district court here, because you're not going to have gone to the Sterling Heights court within 10 days to take care of the matter. So by the time you get to this court, right, they're going to charge you for not appearing in the administrative court of Sterling Heights. And because you didn't appear, well, they're going to say you're in contempt of court, and then they're going to take it to the big court, the state court of the 41st A district, to have them enforce their ordinance. But a civil infraction can't have any jail time attached to it. A civil infraction is nothing more than a fine. And then, I declare in a penalty of perjury that the statements above are true to the best of my knowledge. Complaint and signature, officer's printed name, right? These are things they're not doing. Now, I said it looks a little bit like it, or pretty much like it, but it doesn't look like it all the way to the end. Right? because so this here says, I served a copy of civil infraction complaint upon defendant. That's what the A says. Now, this is the B, because I got another one. Right? Called the same thing. They're both called State of Michigan Uniform Law Citation. But this other one says here, I have personally served a copy of the complaint on the defendant. I served a copy of the complaint upon the owner-occupant by posting. Right? So that part there is different than this one here. This has got one box. This has got two boxes. This one says it's a complaint. This one says it's a civil infraction. One's used for a misdemeanor and the other one's used for civil infraction. But the city of Sterling Heights, at least, somebody's using the civil infraction one, and they're going to charge you for a crime in the people of the state and the township. Well, a civil infraction, you can't charge me for shit in the state. You can only charge me for shit in the city. Because civil infractions are infractions of an ordinance. So, the form looks pretty much correct, but I don't believe that it is. Now, but the big thing is, see, complainant's signature, an officer's name printed. And what you're going to get, if you get one of these, it's going to say Trooper Smith. And if he signs it, it's going to say Trooper Smith. Well, that isn't his name, and that isn't his signature, right? So that's the error that's on the form. Now, this form is going to go from Trooper Smith to the prosecutor, who's going to try to prosecute you on this, knowing that it hasn't been signed. It's not a signed or sworn to complaint. All right, I declare under penalties of perjury that the statements above are true to the best of my information, knowledge, and belief. If he's a peace officer and he signs his name and fills this out and does the rest of the stuff, he doesn't need to go before a magistrate to swear out a complaint. It is the complaint. If it doesn't have those things, he does have to. And they're not doing it. So that's the way the one in Michigan looks. And they have this other one that is more, now this one I believe is like for a misdemeanor. Now, violation of which court may waive fine or cost. Correct the violation. Present the citation to any law enforcement officer to certify the correction. Mail or bring the citation to the court clerk at the address shown above before your appearance or hearing date. So this is something you're supposed to be doing. And you're going to point out, hey, the dude didn't sign his freaking complaint. And you should be able to take it to any law enforcement officer. So, again, these are front and back forms. I'm going to find out, because they're going to file this thing with the District Court Register of Actions. I never heard that used before. Who's the District Court Register of Actions? Here's the back sides of these forms. The court copy. Alright, so we should be going looking for these other copies. You get one copy of a 6-thing form. There's 5 other portions out there someplace. It'd be interesting to see what they have on them. Okay. Talked about that. What else was there on here? Volume 2. No, how am I going to find it in there? It'll take too long. Okay, hang on a second. Okay, I don't know what this was called. It's called the Civil Infraction Traffic. That's the name of it, right? Something I found online for the state of Michigan. And it talks about on page material defects. A citation must be checked for material defects. This is what the magistrate's supposed to do. A material defect is an error pertaining to a fact that is necessary to prove an element of the offense, or that attacks the essence of the complaint. See section 6.25, C2, I guess that's in here, and the traffic bench book. So I got a thing called the traffic bench book, volume 2, section 1.8. Courts vary in their opinion as to what constitutes material defect, and new magistrates should check with their chief judges regarding the issue. Material defects may include no signature on the citation by the citing officer. The absence of a signature is a material defect that makes the entire citation invalid. Michigan Compiled Law 257.742, bracketed 1, whatever that is. Incorrect identification of the defendant. Right? If they don't put you down as Robert Allen Brytlewski, then he didn't serve me. Incomplete identification of the offense. Failing to specify the location of the offense. Failing to specify the date of the offense. Right? In other words, errors or omissions on the form can be considered material defects, and you need to go point them out to somebody, because you point out the right one, they're going to say that the citation is invalid and that they'll dismiss the case. But we want to point out, well, when we find these things, we want to say, because they do go to the prosecutor, that the prosecutor is committing professional misconduct as an attorney by using these fraudulent forms in court. And he's supposed to be learned in the law and not supposed to make these kind of mistakes. And you pointed out to the attorney disciplinary board, and you provide the evidence, which is your frickin' ticket you got, and point out what he did wrong and give it to as evidence to this administrative board set up by the Supreme Court to be the board looking for probable cause before there's a hearing. The other thing you might do is you might take it directly to the state court administrator saying this form isn't correct and it's a violation of the Supreme Court rules, and you want the Chief Justice to hand down a mandamus to the court below to do or not do whatever it is needs to be done. You know, to the not just the court, but the mandamus can go to any public office, official, whatever. Right? And that's how you get it, by you bringing the complaint administratively to the clerk over the administration of the administration, which is the administrator, who's acting as the clerk for the chief judge, who's the chief administrator, executor, executive, because that's what administration is. It's not the judicial side, it's the executive side of the court. And we're not trying to get the law judged, right? There's no controversy. We know what the law says. The law says they need to do this. Execute the law. And we can, without going into what the Michigan compiled laws say or your revised statutes say or any of this other stuff, we keep it within the framework of their little private society and its rules of conduct and attorney discipline and all that stuff is in there, and you point out what they've done wrong and, you know, see what that does. That's what we're going to be trying. There's a few other things I wanted to point out that had to do with contempt of court, because that's just as big as anything. And Rob Ryder, hey, he still needs your money. Where was it? Been trying to figure out for the longest time how you get a complaint, right? Because you have indictments informations and complaints. Well, an indictment comes from the grand jury, and it goes to the prosecutor. An information is something that you fill out at the counter, and it goes to the prosecutor. And the prosecutor gets to decide what he's going to prosecute. So, if they don't like your information, they're not going to prosecute them. Then there's this thing called complaints. We've been trying to put complaints in before the proper magistrate for the longest frickin' time. Well, there was this case here. So this is out of Illinois. People versus Detterman. As an issue of first impression, the appellate court found that 750 ILCS 1610, which provides that a criminal prosecution for willfully failing to provide for a support of a spouse or child may be instituted and prosecuted only upon the filing of a verified complaint by the person or persons receiving child or spouse support. Requires that a verified complaint be filed with the circuit court before criminal proceedings are instituted. The court rejects the state's arguments that that particular section is satisfied by filing a verified complaint with the state's attorney's office. Right? So you don't take your verified complaint to the state attorney, the county prosecutor. You file it with the court, with the lowercase circuit court. Now again, this is in Illinois, and the lowercase circuit court is the Circuit Court of Illinois. Right? You don't take it to your state attorney, you go to the Circuit Court of Illinois. And who represents the Circuit Court of Illinois in your circuit in Illinois is the chief judge of the circuit, who has an administrator. So they are like a miniature of what the Supreme Court is, where they've taken one judge, set him aside, say you're the chief administrator within the circuit, and we're going to give you a frickin' administrator to help you out, a clerk. Right? And the rest of us are going to be in the courts doing the business, and we have the clerk of courts. Same thing in the Supreme Court. Right? The Supreme Court has got the clerk of the Supreme Court. That's where all the appeals and stuff go. But we're not appealing. This is an original action pointing out, hey, this is going on. Enforce your law. It's more like a praecipe. The court rejected the state's argument, infers that the state's attorney exclusive discretion to initiate and manage criminal prosecutions. Although the filing of a verified complaint with the trial court is a necessary prerequisite for the state's attorneys to file a charging instrument, once a verified complaint has been filed with the state's attorney, the state's attorney retains discretion concerning whether or how to prosecute the case. So, you think about it. They're saying, you can't file it directly with the state's attorney. The court won't know that you put the complaint in if you give it to the state's attorney. And so he may just decide not to do anything with it. If you want the trial court to know, you need to give it to the trial court. And what's your complaint going to be? Well, you're going to complain that the state's attorney is involved in indirect contempt of court because they're using a form that hasn't been prescribed by the group that approved the form. Defendant received citation for violations, naming people the state of Illinois as prosecutor. I don't know why I had that on there. I guess that was the biggest thing is you're supposed to go before the circuit court. Jurisdiction stems from Illinois' Constitution, which assigns original jurisdiction to the circuit court in all justicable matters except where the Supreme Court has original and exclusive jurisdiction. Right? Original and exclusive. Now, what things do they have exclusive jurisdiction in? Very few. They may have original, which means you could start it there or you could start it in this court. But the jurisdiction stems from the Illinois Constitution, which assigns original jurisdiction to the circuit court in all, right? That's why it's the court of general jurisdiction. And so you want to bring to them the fact that there's been a complaint. You need to put a complaint in before them. And the chief judge has got their own courtroom, but they don't hardly ever sit in court to hear court cases. That's just my impression, right? I'm not even absolutely sure I know this stuff. A charging instrument is sufficient to state an offense where it is in writing, sets forth the nature and elements of the offense, and alleges the provision violated, the name of the accused, and the date and county of commission. Okay, right? So, per your rule, whatever, of your professional conduct, right, this is what's happened. Which is in violation of some statute number. And you wrote it. You're going to go give it to the judge in open court. And see what they do with it. Tell them I need to file this with the circuit court. Are you not the circuit court? Right? Maybe you mail this. So now here's one thing that Roe was told before is if you want to contact the chief judge, you need to do it by mail. Okay, so that's what you do. You mail it to them. Now, why would that be important? Well, because there's a stamp on the frickin' envelope, and that may have paid the frickin' stamp tax, which is necessary for instruments to be considered lawful instruments. They need to have paid the stamp tax. A motion to dismiss a charge for failing to allege an offense challenges the sufficiency of the allegations of the complaint and does not concern the evidence which might be introduced to support the allegation. Right? A motion to dismiss a charge for failure to allege an offense challenges the sufficiency of the allegations of the complaint. Which is really what we're doing because, when they put in these tickets, they're complaints against you, and we're saying, hey, they didn't do it right. But you want to point it out as indirect contempt of court. To me, that's a biggie. Because I want them to stop, right? So, indirect contempt of court. This is some other things out of Illinois, out of some other things that I read. Indirect criminal contempt of court, by contrast, involves conduct the judge has not personally witnessed. Accordingly, indirect criminal proceedings must be initiated by a petitioner's written request for adjudication and give rise to similar procedural safeguards as those required in criminal proceedings, including the right to be advised of the nature of the charge, to be yada yada yada. It's indirect criminal contempt. So, typically, indirect criminal contempt involves a situation where the accused willfully ignores a valid court order. In some unusual situations, indirect criminal contempt involves disrespectful acts of the court's authority, even though such acts were not witnessed by the judge. Well, that would be using the wrong form. Defendant was in traffic court waiting to appear on a speeding ticket. When the judge took a recess, defendant was left the courtroom. In the hallway, a bailiff overheard her say, "I waited all fucking morning, and now she takes a break." The defendant walked all the way down the hall, continuing to swear. The bailiff told her she could not use language, and the defendant calmed down. After the bailiff told the judge about the defendant's comments, the judge instructed the state, right, which would be the state's attorney, guy sitting there, to prepare and file a petition for contempt. The state drafted a document entitled Court Order, which ordered the defendant to show good cause as to why she should not be held in indirect criminal contempt of court. The judge denied defense counsel's request for a short continuance to prepare for a trial. So all this is happening right in the court. And the case was not criminal, but basically civil in nature, and proceeded to trial immediately. So they didn't do this step right, but it just goes to show that the judge told the state to prepare and file a petition for contempt, and they didn't leave. They just stayed there and went through with it. She wrote up a court order. The state drafted a document entitled Court Order. Well, that isn't what it should be drafted. It should be drafted and called a petition for adjudication of indirect contempt of court. That's what they want you to put in Illinois. Bailiff testified about what she observed, and after arguments by counsel, the judge found the defendant guilty of criminal contempt and sentenced her to 8 days in jail. In making her findings, the judge again stated that the case was civil in nature and the standard was preponderance of the evidence. The judge found the defendant did not do something that she was told to do and engaged in an outburst that gave disruptive to my court and the administration of justice. The judge also found the words to be very disrespectful. At the end of her findings, the judge stated that it was criminal contempt, and if you want to say beyond a reasonable doubt If that's the standard, we'll find that beyond a reasonable doubt. Just making stuff up as you went along. Right? So, a couple other ones. Criminal contempt may be direct or indirect. Direct criminal contempt of court can occur in two ways. A contemptuous act may be personally observed by the judge, or the act may be committed outside the immediate physical presence of the judge, but within the integral part of the court, such as the circuit clerk's office. Under appropriate circumstances, filing a document with the clerk of court may be the basis for direct criminal contempt conviction. And so this may not be indirect, because if you're writing the letter to the circuit clerk's office, and we're going to say that's the chief judge's office, to point out that the form that they were supposed to get within 48 hours, just real quick, right, Supreme Court Rule 552 says the arresting officer shall complete the form or ticket, and within 48 hours after arrest shall transmit portions entitled complaint and disposition report, and where appropriate, report of conviction, to the clerk of the circuit court of the county in which the violation occurred. So if they send those to them and they're not the right forms and they don't comply with the law, then it's really direct criminal contempt of court. One element of contempt is that the conduct must have been willfully committed. And I think so. You need to put on there, they willfully did this. They willfully used the wrong form in contempt of court. So if you were to point out Rule 522 to the judge, right, so that's my point. Okay, so you point out Rule 522, what it says, and they were supposed to send this, and here's what they must have sent, because on Rose it's got a case number on it. They put a number on it. Then whoever did that excuse me, is in direct contempt of the Circuit Court of Illinois, and there's only one of them. And again, that goes to, the way that they Circuit Court of Illinois, there's one. Not Circuit Courts of Illinois, Circuit Court of Illinois, of which there's different judicial circuits. So these circuits are like districts within the circuit, that within that particular district are judges that ride a circuit. That's how it would have been back in the day, but they're not riding circuits anymore. And one other thing that we found was interesting is the Circuit Court of Illinois' 6th Judicial Circuit, Piatt County, Monticello, Illinois, they have fees for the general division, and we haven't seen these before. And now this is the crazy stuff. See all these filing a case whatever they are, and it's listing some 105.27, 105.27.12 D2. You cannot find these online. 705 ILCS 105/27 is the Clerk of Courts Act. But these 1.82s, 1D1, these aren't online. You can't find them online. It's not in the statute that you find online. They skipped over this section of 1G2, 1L3. These are, so we got to find these, and, well, where would they be? They would be with the Circuit Court of Illinois, 6th Judicial Circuit. So Roe sent this to the Clerk of the Court's office in her county, and they said, you can find the civil division fees online. Again, just rejecting the fact that we want the general division. They said the civil division, and this specifically says the general division. Because this is important for one reason. When you get down here, so here's the fees. Where is it at, man? Where is it at? Law division, probate division, small claims, criminal traffic. All right, misdemeanor charges. The fee for a misdemeanor charge in the criminal and traffic division of this court is $120. That's all there is. There's no court fees. You should pay $120. Well, they took $120 from Roe, but obviously they didn't give it to the right division. In my opinion, that's why they're still after her. So, again, they got 1C2. You can't find that online. 1C, can't find that. 1P2, can't find that. All right, 1Y, can't find that. Those are all somewhere else. And so we're going to contact the Circuit Court of Illinois, 6th Judicial Circuit, by email, because they don't really know where the emails come from, and say, hey, please send me the law that you've put on your form. Because they're the ones who are quoting it. Excellent. Well, now give it to me so I can read it. Okay. So, in conclusion, they're using the wrong forms. It's criminal contempt of court because they've already committed the crime. And it's against the Supreme Court, who's the one who's decided. They're the ones that have decided that this is the form you're supposed to use. And so, if you want to exhaust your administrative remedies, you need to go to the Chief Judge of the Supreme Court, who's tasked with enforcing the rules of the Supreme Court. Possibly. And you would do that by going through the court administrator, not the court clerk of the Supreme Court. Step down one step, you got a chief judge over whatever district you're in that has an administrator that you could take the contempt of court to, pointing out that the prosecutor is in contempt of court because they're using a form that has not been approved by the Supreme Court. And for that judge not to do something about it would put them in contempt of the Supreme Court. And because you're an attorney under this name and you have a professional code of conduct, you need to point out the crime. I'm pointing it out to you. You need to point it out to whoever needs to be pointed out to make it go away. Or I'll point you both out. So, look really close. This stuff wasn't that hard to find. Just a uniform traffic ticket, whatever your state is, right? Uniform citation, whatever your state is. Start reading. It's all going to be on the first page of Google, first 2 pages of Google. You're going to find who's in charge of it, who made the form, who approved it, and if you want to change it, what do you need to do to change it? And then if you got one, go look at it, even if it's already happened. Go find the one they got you with last year and say, hey, this isn't what it shows on here. You can still appeal it. Right? Because it was fraud. There's no time limit on fraud. Right? But there is a time limit on me paying my rent. I'm 7 days behind. So really, man, if you guys can help me out, I'd like to at least be able to take a breath and say, hey, thank you, and pay my rent. But I can't do it yet, and I don't know how long I can hold my breath. But I guess we'll find out. Okay, y'all take care, and we'll see what this week brings. Have a great day. See ya.